Hi, my name is David Brett. I'm the editor of the New Westminster Times. I'm standing at a very important location in British Columbia now. It is the site of the Cowichan Tribes land claims decision. Behind me, their archaeologists say there was an ancient Cowichan village along the banks of the Fraser River to my left. But as you will see behind me, we have a significant amount of industrial development here, and this has caused a major problem because the courts have decided to award private property, effectively Aboriginal title, which is usurping and rendering invalid the fee simple private property rights of the people who are resident here. The fuel derricks behind me are for YVR, and that is sitting on federal land. So why is it that this decision in British Columbia has caused such public outcry and consternation? I would say that there's a number of factors at play, one of which is the facts in the case itself, but it's the larger context of the decision that I think bears analysis, that has caused a shakeup in the province. And the context is one where the public, the general public, has been led through kind of a funhouse hall of mirrors, of sloping floors and warped walls, where the relationship with Indigenous people across the province has been explained in very contrasting and different ways that are causing almost a level of insanity amongst people who are trying to figure it out. To give you an idea of why this is, I would explain it this way. The grounds for the decision in favor of the Cowichan rest upon the beneficence, if you will, or the honor, what the court calls the honor of the Crown. The Crown being the British imperial power that colonized these lands so many years ago. So this kind of fundamental right to title to land did not come out of thin air. It rests to a large extent on a proclamation that was made in 1763 by King George. Aside from setting out the parameters of the British holdings in America prior to the Revolution and in Canada, it set out broad principles of justice and fairness in which the Indigenous people of the lands would be treated. There were to be no frauds and abuses. There were to be no private land sales. A principle was established where the government, the Crown itself, and only the Crown, was permitted to make treaties, except for special cases such as the Hudson's Bay Company. So this broad appeal to the good nature of the British colonies was to be extended. The lands of the Indigenous people were to be respected, and there were to be treaties made. In contrast, after the American Revolution, this proclamation was ripped up, and the settlement of the American West was very different from Canada, and that the Canadian settlement was under this broad honor of the Crown. Well, contrast that with what we're being told by activists and politicians across this country, and even in this government, that the Crown is not honorable. It is ruthless, vicious, genocidal monsters. That Canada itself is a racist establishment which is founded precisely to wipe out Indigenous people. These two contrasting views of the Crown and the approach of Canada to Indigenous people is tearing at the fabric of our society. They both can't be true. A few short kilometers away from me, it's behind my shoulder, the city of New Westminster, the province's first capital, the colony of British Columbia, they decided to rid the city of its Royal City moniker and replace the crown logo, which had been there. It's ubiquitous, the crown, because it was put forward that the crown and the royal pretensions were offensive to First Nations people. So if you think about what's really happening, the crown is actually stepping up and supporting Indigenous people. The decision in favor of the Cowichan people rests on the crown's dictates that were made so long ago, and the representations of the people who were designated by the crown to negotiate treaties. So we are told, and that because of reconciliation, that decisions like this are naturally flowing out of reconciliation with First Nations people. The word reconciliation occurs 154 times in the judge's decision regarding the Cowichan Tribes, and in this very place. And the lens of reconciliation was used in the decision. The problem is we are not in an age of reconciliation. We are in an age of decolonization. Decolonization is effectively the opposite of reconciliation. And what do I mean by that? The decolonial pursuit is not to reconcile Indigenous people with European people or settlers or people who have come here who are not Indigenous. It is to extinguish, wipe out, remove, cast away and portray settlers as somewhat of an evil force, that colonizers are inherently evil and wicked. This image of the colonizer is made no more stark than in the Palestine-Israel conflict, where people at Palestine rallies will portray the Jews as colonizers, and the slaughter of innocent civilians in Israel is deemed to be justified because they're not innocent, they're colonizers. So this rhetoric of the colonizer and settler versus the Indigenous person creates an underlying hostility and potential for violence. So this is all very unfortunate, because my reading of the Cowichan case indicates that there is a very strong case that the Cowichan have to these lands, and that somehow a promise was made to set aside these lands as a reserve, and it was never followed through. The governor of the colony of British Columbia at the time, James Douglas, in 1853, reportedly made a promise to the Cowichan people to, in exchange for peace with their people, to set aside multiple locations as reserves, and that they need not worry about their lands being taken. Well, it never happened. For whatever reason, this particular location was not set aside. So these facts are being lost in this cloud of confusion over what the real responsibilities are of, the residents of BC who are not Indigenous are. So the people who hold fee simple interests here in these lands are now thrust into an extremely complex situation where they are given stark news that their properties, such as this massive complex behind me, what are they going to do? Going to dismantle this facility? People are going to have to move off of their homes and move away? Nobody really knows what's going to happen. So the news is that the Government of Canada, the province of BC, the city of Richmond, and other parties are appealing this decision. So the problem with the appeals court is that no new evidence can be adduced at the appeal stage. The appellants in an appeal must show that the judge erred in law in a palpable way and palpably erred on the facts. This case took apparently over 10 years and involved over 500 days of court time. The experts who tendered evidence were not only anthropologists or archaeologists, they also included what the court called Indigenous knowledge holders. So people providing evidence based on not their first-hand accounts, but memories that were passed down to them from other people. And normally this would be called hearsay evidence and is typically not allowed. But for whatever reason, the court has deemed that these testimonies would be allowed. So, in closing, I would ask this question. What are the chances of this decision being overturned? What palpable error did the judge make? The only thing I can think of is that the reconciliation lens that was invoked is not a legal basis for judging the matter. And also that the testimony of the quote-unquote knowledge holders was heard. Any evidence that's heard that should not have been heard could cause the case to be overturned. It's interesting that other Indigenous nations are fighting this. And speaking of fighting, an interesting aspect of the case is that the fierce military strength of the Cowichan people is one of the pieces of evidence that augurs in their favor. In other words, because they were able to protect their rights through military force, that strengthens their claim. The Cowichan, from what the historical record appears to show, were not welcome here. They held this ground through fear and military power because their main year-round living was on Vancouver Island. They were referred to in the court documents as people from the sea. They came across the Strait of Georgia and occupied these lands in the summer to fish and were seen as an invading force. So no matter what the narrative is in today's decolonial concept that the British Crown were ruthless destroyers and killers and violent people, this court case clearly shows that the Cowichan were very violent people, and they held this ground through threat of violence. And it was partly that violence that Douglas seems to have decided to negotiate based upon that, well, we want peace, so we're going to give you this land. It didn't happen. Were there reasons for it? In any case, this is playing out at a time when people are feeling like their lives are being undermined by politics and ideology that does not square with reality, does not square with the historical record, does not square with the honor of the Crown, it does not square with the true history of the province of BC. I would recommend that everyone read this incredibly long but very interesting document. It's like a free course in law and in the history of British Columbia. It's quite incredible, and I think the more people engage in knowledge sharing and learning, the better. Thanks for listening today.